not expected to know all the law by Lohel A. Martires. Lawyers have been administratively charged in court for professional incompetence, malpractice, dishonesty, and other kinds of accusations may be found or produced. It is also said that lawyers must use their full knowledge and capacity in an honest, serious way in order to attain and maintain a free and orderly society, being lawyers are the standard bearers of the law. It is also said in this annotation that lawyers are not robots. They have their own minds, therefore they can commit mistakes. And with regards to committing mistakes, honest mistakes, however, which can subject them to administrative charges, but they cannot be punished on groundless or unsupportive charges. Lawyers are humans, are human beings with their own rationality, and being so, they are not expected to know all the laws as a human being, because we all know that it is factually impossible. The scope of this annotation covers all lawyers in any field they may be, in the academe, in the government, or in private practice, are bounded by the same oath and covered by the same canons of professional ethics. Lawyers are men of law. They should lead and live a life under the law, not above the law, and they are expected to be just or to promote justice at all times. In this annotation, there are many related matters, which includes the disbarment proceedings, the grounds for disbarment, the definition of practice of law, also the definition of the license to law. And in Section 27, Rule 138, this is the grounds for disbarment. Attorneys removed or suspended by the Supreme Court on what grounds? A member of the bar may be removed or suspended from office as attorney by the Supreme Court for any deceit, malpractice, gross misconduct, grossly immoral conduct, conviction of a crime involving moral turpitude, violation of oath, willful disobedience of any lawful order or any superior court, and corruptly or willfully appearing as an attorney for a party without the authority to do so. And it is also said that the practice of soliciting cases at law for the purpose of gain, either personally or through paid agents or brokers, constitute malpractice. And there is a definition of moral turpitude, as I said a while ago. Lawyers are disbarred whenever they committed a crime involving moral turpitude, and moral turpitude is defined as, used in this section, includes any act done contrary to justice, honesty, modesty, or good morals. Power to remove or suspend. It is well settled that a court authorized to admit an attorney also has that inherent jurisdiction to suspend or disbar him for a sufficient cause. And that such jurisdiction does not necessarily depend on any express constitutional provision or statutory enactment, meaning that if the court has the power to admit a person to a bar, therefore the court also has that inherent power to suspend or remove a person from the bar. The disbarment of an attorney is not intended as punishment. Again, it is more like to be protective. For the public. Remember that the statutory enumeration in the Section 27, Rule 138, is not to be taken as a limitation of the general power of the courts, because whether or not that these lawyers have done which is included in the grounds of disbarment, the court also has that power to decide so, even if that things or acts done is not in the grounds of disbarment. The power of the courts to exclude unfit and unworthy members of the profession is inherent. It is a necessary incident to the proper administration of justice. In this annotation, a case was cited which is entitled Arsenio Mendoza, complainant versus Arsenio Mercado, the respondent. This is an administrative case number 1484, wherein Arsenio Mendoza, the complainant, filed an administrative case against Arsenio Mercado for professional incompetence. Arsenio Mercado, being the Assistant Provincial Fiscal of Bulacan, notarized a deed of donation mortis causa, which was declared void by the Court of First Instance for not having been executed in the form of a last will and testament. Here is the definition of donation mortis causa, wherein, to summarize it, donation which are to take effect upon the death of the donor, partake of the nature of testamentary provisions, and shall be covered by the rules established in the title of succession. Again, donation mortis causa is that which becomes effective upon the death of the donor. Because of the nullity of the deed of donation, the last will and testament of Felisa Mendoza became ineffectual or inoperative. However, the decision of the Court of First Instance in Bulacan declaring the donation void is still pending. And Arsenio Mendoza contending that the donation is valid because it was executed in accordance with the law. The issue here is whether or not Respondent Mercado prepared the said deed of donation, mortis causa, or merely notarized it. And the ruling, or it was found out that the deed of donation was prepared by lawyer Joscoro M. Juan, also the mayor of Bukawi, Bulacan, a relative of the complainant Mendoza, and that Mercado acted in good faith in notarizing it. And also, as said a while ago in section 27, 138, professional incompetence is not among the grounds for disbarment specified in that rule. Nonetheless, we must take note that we must always remember that the enumeration on the grounds, as I said a while ago, the enumeration on the grounds for disbarment in section 27 is not exclusive, and that there may be a case where a lawyer should be disbarred for inexcusable ignorance of the law. But however, in this case, we are satisfied that disciplinary action should not be taken against the respondent for having ratified a deed of donation mortis causa which was not form of a will. According to the Supreme Court, one has only to read the decided cases on the controversial issue of when a donation should be regarded as inter vivos and when mortis causa in order to know that some lawyers are inexcusably unfamiliar with the rule that the donation mortis causa has ceased to be an independent legal concept in the Civil Code and that it should have the form of a last will and testament. It is cited in this case from Chief Justice Abbott, that an attorney at law is not expected to know all the law. For an honest mistake or error, an attorney is not liable. Because no attorney is bound to know all the law. God forbid that it should be imagined that an attorney or a counsel or even a judge is bound to know all the law. Wherefore, the complaint for the disbarment against Arsenio Mercado was dismissed. And lastly, so these are the last notes taken in the annotation. Our Supreme Court, citing Chief Justice Abbott in the case, under annotation, no attorney is bound to know all the law. God forbid that it should be imagined that an attorney or a counsel or even a judge is bound to know all the law. Law is older than man, even older than the universe. Hence, it is believed, as mentioned earlier, that to know all the laws is an impossibility. And these are the important things to remember in this annotation. First is, lawyers are not robots. They have their own minds, therefore they cannot commit mistakes, honest mistakes which can subject them to administrative charges, but they cannot be punished on groundless or unsupportive charges. Lawyers are humans with their own rationality, and being so, they are not expected to know all the laws as a human being because it is factually impossible. Law is older than man, even older than the universe. Hence, it is believed, as mentioned earlier, that to know all the laws is an impossibility. And again, in the case of Arsenio Mendoza versus Arsenio Mercado, AM number 1484, in the ruling, the Supreme Court cited Chief Justice Abbott, an attorney at law is not expected to know all the law. For an honest mistake or error, an attorney is not liable. No attorney is bound to know all the law. God forbid that it should be imagined that an attorney or a counsel or even a judge is bound to know all the law.